financing closing that Mr. Stone and Ms. Craig were using for the construction loan. But that all of these contracts are the same. There are at different points in time, depending on when they were signed, they have different numbers of exhibits. None of those exhibits are at issue here. If Mr. Allen had raised a prior point that the contract is incomplete, to the extent it is right here in terms of a complete contract with a 50-page warranty and all the other exhibits. None of those are at issue here. For the sake of the pulling this up and using it in Zoom, I'm going to refer to the contract that was signed both on the February 28th date and the March 6th date. So I'm clicking on that one. So that's the one that's being pulled up right now. This was our exhibit, both claimants exhibit 1, but it's also the joint exhibit that Mr. Allen and I had agreed to. I'm going to scroll through the contract down to the relevant provisions. So this is paragraph N on page 12. So this is where the arbitrator had referenced having the authority to arbitrate. In this particular provision of this contract, it does give that authority to the AAA if the parties are unable to agree on an arbitrator. And since they didn't, the AAA was empowered. Ms. Stark did the arbitration. As you go to the next page of the contract, there's a couple of relevant provisions that I want to point out. P, mutual limitation of claims and remedies. P1, limitation of claims. Under no circumstances shall either owner or builder be liable for any special, indirect, or consequential damages. That's one of the points at issue here, Your Honor. We have in this particular case an award that, as I mentioned just a minute ago, provided for demolition costs of $42,300. That is a special damage, consequential damage. It is specifically excluded from being able to be awarded under this contract. Also, scrolling to the next page, page 14 of the contract, paragraph R. Paragraph R is attorney's fees, and then it goes through the detail of whether or not builder or owner is a prevailing party. Then that's who is awarded attorney's fees. It says such party shall be entitled to recover its attorney's fees, court arbitration costs, and any other litigation expenses from the non-prevailing party. Ms. Stark, the arbitrator, awarded the actual attorney's fees only to Mr. Stone and Ms. Craig. The prevailing party, however, is defined here, and it says shall be deemed to be the party whose last written offer to settle the dispute or the fair market value of the offer before the initiation of the proceeding arbitration most closely approximates the final award. Obviously, that's to encourage the parties to settle. If the claimant makes no written demand or offer, its last offer shall be the amount claimed in arbitration. Similarly, if the defending party makes no written offer, its last offer shall either be zero or, if applicable, the amount of its counterclaim. And so we have that definition that we are working with, and I'm going to move over and show you relevant documents to that. back to the pleadings folder. This is going to be under the statement of claims.
You're going really slowly here. This is only scheduled for 45 minutes, and so maybe you can bullet point like what is exactly your what is your claim here? I'm not even.
Okay, so this is to the point as far as attorney's fees go. To give you a brief, and I was trying to show you the evidence of where that is, but the prevailing party is whoever's closest to their initial demand. We demanded, Meadows Homes demanded $226,000 to $226,926.42. The only written from Mr. Sun and Ms. Craig was a demand for $400,000 in their counterclaim. The midpoint between those two is just under $87,000. What was awarded by the arbitrator is $42,300. And so the prevailing party under that contract that we just walked through is actually Meadows Homes, and Meadows Homes is entitled to recover its attorney's fees.
Okay, that's helpful. What's your response, Mr. Allen, to that?
Yes, Your Honor. As I've indicated previously, this court's sitting as an appellate court, and if Meadows Homes is saying that the arbitrator made a mistake of fact or a mistake of law, I'm sorry, Your Honor, my screen is scrolling. Could you, maybe Mr. James could unshare?
Do I need to unshare, Your Honor?
I'll do it. Go ahead.
Oh, okay, thank you. And in a minute, I'll ask you to let me share.
You're allowed to share.
If there is a mistake of law or fact, that's not a reason to modify or to vacate the award. The plaintiff in this case has to show that the issue wasn't submitted to the arbitrator properly. Now, and I've already indicated that the courts say that you have to have a complete record to make that determination. But just to follow up on that note, that concept, as part of this litigation, we presented into evidence a subsequent contract. I'm going to refer to it as the Prosperity Bank contract, which was the contract between Meadows Homes, my clients, and Prosperity Bank for the construction of this house. We pled that was a novation, and I think that it's it appears to me, since the arbitrator awarded us damages on our claims, that she must have gone along with that. Now, Mr. James is stating that she must have been relying upon the earlier, I'm going to refer to it, Your Honor, as the TAB contract. It's the Texas Association of Builders, which was the earlier contract that Mr. Sohn had showed to you. If you could, Your Honor, could you let me share my screen?
It's already enabled. You can share your screen.
All right. Thank you, Your Honor. All right, Your Honor, is that up on the screen?
It is.
This is one of the versions, as Mr. James indicated. There are several versions in this of this contract that were introduced, signed at different times and everything. And I want to go back down to the mediation section that Mr. James was relying on. I'll get there in just a second, Your Honor. All right, Your Honor. This is the section that Mr. James was referring to, I believe, earlier, talking about mediation and everything, and that the arbitrator must have been relying upon this contract in making the award of damages. And I would show to the court that that's not correct. On the top of page 13 of this contract, of this particular section, it says, owner and builder agree that notwithstanding anything to the contrary, the rights and obligations set forth in this mediation arbitration agreement shall survive the termination of this contract by either party. Even though there was a novation of the contract between the parties, or it was our contention that there was a novation of the contract between the parties, and that the Prosperity Bank contract was the actual contract that existed between the parties. Nevertheless, the mediation arbitration portion of this contract was set to survive. And so our position has always been that as far as requiring us to go through mediation, which we did, and requiring us to submit this to arbitration, which has been done, that survived the fact that this contract was subjected to a novation. If you will, I'm going to stop the share and go to right, I'm going to share a different screen. This was the third amended summarization of respondents' claims and defenses that was filed on June 27th in this particular case prior to the arbitration agreement. And as you will note under breach of paragraph section number 10, it says, the contract that has been alleged by claimant in its initial claim for arbitration is not the contract between the parties, in that it is either incomplete and or was replaced by a novation upon the execution of the mechanics lien contract with transfer of lien signed on March 6, 2020 between Kurt Sohn and Belinda Craig, Meadows Homes, and Prosperity Bank. The awards that were given to us by the arbitrator are not awards based upon this contract, but is instead awards that were based upon the claims that we pled of breach of contract and breach of warranty. The attorney's fees, which the arbitrator awarded to us, was not attorney's fees awarded to us based upon the February 28th contract that Mr. James is referring to. Those were attorney's fees awarded to us on our affirmative claims, which would have been the breach of contract and the breach of warranty. The arbitrator did, this case was submitted to the arbitrator based upon the savings clause in the February 28th agreement. But the February 28th agreement, in all other respects, had been replaced by the March 6th agreement with Prosperity Bank. These claims were submitted to the arbitrator. They're part of our third amended summarization of respondents' claims and defenses, which is attached, which was attached to the answer that we filed in this case. And this was pointed out or briefed to the arbitrator in the amended pre-hearing brief that was also attached as an exhibit to the answer that we filed in this claim. Let me share one more screen. Well, that's interesting. All right. This is the answer that we filed with this court in January of this year. The award, the arbitrator's award, is on page 136, I believe. Blow that up. And as you will see here, the counterclaim reward was for cost of demolition caused by claimant's breach of contract and breach of warranties. And the attorney's fees that were awarded were attorney's fees based on the affirmative claims that the respondents had filed in this action.
So what do you make of this argument that the demolition costs are consequential damages and shouldn't be recovered?
Well, Your Honor, the only place that appears is in the February 28th contract, which was replaced by the March 6th contract, except as to the section that said that it would survive termination, calling for a mediation and arbitration. The contract that Mr. James is asking the court to enforce is clearly not the contract that the arbitrator based her awards upon. And the fact that even if she was wrong in doing that, this was presented to the arbitrator as part of our summary of claims, as part of our pre-hearing briefs. And so it was she was given the authority to make a determination of those issues. And that determination cannot be attacked just because Mr. James thinks that it was incorrect in law or in fact. That the deference that the courts are required to give to an arbitrator basically require that the only way that her award can be set aside is if she made a decision that was not submitted to her. And in this particular case, she made a decision that the pleadings show clearly were submitted to her.
I object to that, Your Honor. I think there's other bases for which award can be vacated and modified and corrected.
Okay. What alternative basis are you relying on?
essentially that she exceeded her powers. And there's also the argument that it's against the policy. But first exceeded the powers. That's precisely where this lands. And Mr. Allen is essentially asking this court to read into the award something that's simply not there. She references the February 28th contract. She says nothing about the March 6th contract. And then if I may share, Your Honor, I'll show something in the February 28th contract that deals directly with this particular point.
Okay.
All right, I'm going to share screen now. So here I have it highlighted under 16. Try to make it bigger. So right here, this is under the mechanics lien, paragraph 16A. The last sentence of that paragraph says, in the event of any conflicts between this contract and any separate builders and mechanics lien contract, the terms of this contract shall control. The Texas Association of Builders, when they drafted this contract, they understand that most people have to obtain a home loan, and most banks provide a contract. This particular contract was negotiated for a couple of weeks between the parties. It's over 50 pages long with all its exhibits. It has extensive warranty. And the parties entered into this. Then we came to closing for the bank loan. The bank piles on several documents, as you may be aware. One of which is a 2-pager. There was no testimony as to anything dealing with that 2-pager other than it was being signed amongst all the other documents while the folks were talking about their vacation. And so what we have here is a controlling February 28th contract mentioned specifically by the arbitrator. No mention of the March 6th contract. And we've got a February 28th contract that specifically contemplates this March 6th Prosperity Bank contract for financing. The February 28th contract is what the arbitrator issued her award under. She just made an error and exceeded her authority under that contract by awarding consequential damages and then awarding attorney's fees against the prevailing party.
All right. Is that it, everyone?
Just, could I make one response, Your Honor?
Sure.
I would respond that the section that Mr. James is talking about is if there are conflicting contracts. In this case, we are talking about a replacement or a novation. And once again, if the arbitrator made a mistake of law or fact, that's not grounds for setting aside her award, because all of these issues were submitted to the arbitrator. And she made that determination. And without a complete record, the court is unable to make a determination as to the factual basis that the arbitrator acted upon, and cannot basically any attempt to waive, or excuse me, any attempt to vacate the award has been waived.
And Your Honor, I would just renew my objection as to any additional record this court, then I would like a continuance such that I can provide the record.
All right. Well, I will tell you, I'm not a huge fan of arbitration. I've actually spoken on various panels about that. I think it's really overused, and the amount of deference that's given to an arbitrator is, I think, excessive under Texas law. Unfortunately, I occasionally in the past have ruled what I thought the law should be, and the Court of Appeals told me that's not the law, and I've been reversed on more than a couple of occasions due to my disagreements with arbitration. My role here, as I see, is fairly limited, and The standard is extremely difficult to overturn an arbitration award. And as much as I may want to do that based on just my views on arbitration and I'm a strong believer in the jury trial, that's not what we have here. You guys agreed to arbitration, and I don't see anything in the record that will allow me, under Texas laws that exist today, to overturn this award. So I'm going to unfortunately have to confirm the award. Has Mr. Allen, have you submitted a
Yes, Your Honor, I have submitted a proposed judgment earlier today.
Earlier today, okay.
And the clerk has accepted it.
Let me just make sure I have the correct version of that. You all see that?
Looks like one of my screens, Judge. It just
our case management system has been really glitchy lately since they added the criminal courts to it. It seems to be a lot slower. Rhonda, how's your Odyssey working?
It's going a little slow, but it is moving. Do you want me to try to look up something for you, Judge?
Yeah.
Okay.
Wait a minute. Okay, I think it just came up and then I closed it. Okay, let me try again. Let's see. All right, let's see. I think it's up now. So is it this that you're talking proposed order for judgment? I don't know if you can see that.
Yes, Your Honor.
Let's see. Okay, that is the correct document. Mr. Allen, can you
Yes,
see?
I'm sorry, Your Honor.
Is this the correct document? Can you see the judgment on the screen?
I see the docket sheet on the screen, Your Honor.
Let me try again then.
But your cursor, I think, was on the right document.
Let me see. Let me try again. Is that it?
That appears to be it, Your Honor. Yes.
Okay. All right, guys, you have a great rest of your day, and we'll see you on the next one. I'll get this signed today.
Thank you very much, Your Honor.
Thank you, guys.
Thank you, Your Honor.
Will you be excused?
You're excused.
Thank you.
All right, give me 1 second.
Judge, while you're doing that, I'll be right back.
Okay.
Judge, did you want me to call any more down? I think, we're gonna be losing number 3 on tomorrow. They said they settled,
No, you don't need to call it for tomorrow. Don't call anything else down.
nothing else, gotcha.
Okay, Mr. uh, uh, I can never submit Corkadale.
Corkadale, yes, Your Honor.
It's good to see you.
Good to
Are
see you.
here for the default judgment.
Yes,
Okay, let me pull that up just real quick. This is Quintanilla versus Embiid.
yes.
All righty.
There's 2 defendants, Wayne Chandler and Luis Gerardo R&B.
All right, Tony, are you ready?
Right, Judge.
Well, let's go on the record on DC 2739 Quintanilla versus Embiid. Counsel, make your appearances.
Yeah, James McCorkadale on behalf of plaintiff Elsa Quintanilla. And with me is the plaintiff Elsa Quintanilla. And she will be testifying in Spanish. So I also have a translator here, Miss Alma Gonzalez.
Okay. Let me first off swear in the translator. If you could raise your right hand. Do you swear or affirm that you'll faithfully translate the matters in this case from Spanish to English, from English to Spanish, to the best of your ability? So help you God.
Yes, I do.
If you could have the witness, please raise your right hand.
Entonces, su mano
That's
derecha.
Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Usted jura que se va a dar el testimonio con la verdad, solo la verdad y toda la verdad a su mejor conocimiento. Sí. Yes.
All right, you may proceed.
Right. First, with regard to the motion itself, it had exhibits A through L attached. And we would like to tender those exhibits into evidence as part of the record for this hearing.
Have you already sent those to the court reporter?
I didn't separately send them to the court reporter. They're attached to the motion, but I can send them separately.
Oh, if they've been attached to the motion, that's fine then.
Okay, yeah, exhibits A through L are attached to the motion. And then we would call the plaintiff Elsa Quintanilla to testify.
All right, is that who I just swore in?
Yes, it is exactly who you swore in.
All right, let's go ahead and proceed then.
Good. Ms. Quintanilla, could you state your name for the record, please?
Oiga, Quintanilla, ¿nos puede por favor decir su nombre completo?
Elsa Dolores Quintanilla.
Can you tell us what happened with regard to your car?
¿Nos puede por favor explicar qué pasó, qué le pasó a su vehículo?
Sí, yo estaba vendiendo mi vehículo en mi casa y llegó una persona que lo quería checar el vehículo. Yo salí y traía las llaves en la mano. La persona me dijo que lo quería checar por dentro. Le abrí las puertas, dijo, abre el motor. Levanté, le enseñé el motor y luego se metió al vehículo.
What she's stating is that she posted her vehicle for sale. And this gentleman reached out to her to look to view the vehicle. So whenever she met with him at her residence to view the vehicle, she opened the hood for him to view the vehicle.
Luego que cerró el motor, donde va el motor, se metió al carro y me dijo que quería calarlo.
After closing the hood of the vehicle, he entered the vehicle and asked her if he could test drive the vehicle.
Entonces dijo, déjame las llaves porque lo voy a calar, y yo le dije que no se podía, pero él dijo, sí, dame las llaves, y me las agarró de la mano, cerró la puerta y se fue.
When he asked her if she could, he asked her if he could test drive the vehicle, she stated that she couldn't. So he said, yes, I can. Let me test drive the car. And he yanked the keys from her hand and shut the vehicle door, turned it on and took off.
Luego después, el vehículo que había traído esta persona estaba atrás de mi vehículo, donde estaba una mujer sentada en el lado del timón. Cuando la persona esta se fue con mi vehículo, ella también arrancó su carro y pasó a un lado mío, yéndose detrás de él.
Okay, whenever the gentleman turned on the vehicle and took off, the other vehicle that he had arrived with, there was a female waiting for him in the driver's side. As soon as he took off with Elsa Quintania's vehicle, the other vehicle proceeded to follow the vehicle as well, passing by her very rapidly, taking off behind her vehicle.
Was that the last time you ever saw your car?
¿Esa fue la última vez que viste tu carro?
Sí.
Yes.
Did he bring the car back after this test drive?
Después que él se llevó el vehículo, él regresó, trajo el carro para atrás.
No.
No.
Did you call the police department?
¿Llamaste a la policía?
Sí.
Was that the Garland Police Department?
¿Esa era la policía de Garland?
Sí.
Yes.
He knew about the car because you had advertised it for sale.
Él sabía del vehículo porque tú lo habías propagando que lo estabas vendiendo.
Sí.
Yes.
What kind of a car was it?
¿Qué clase de vehículo era?
Un Nissan Altima 2014 color rojo.
A 2014 Nissan Altima color red.
How much did you list it for when you listed it for sale?
¿A qué valor lo estabas vendiendo?
A $9,000.
$9,000.
What happened when you called the Garland Police Department?
¿Qué sucedió cuando le llamaste a la policía de Garland?
Cuando llamé a la policía, vinieron dos agentes. Uno era mujer, otro hombre, y les dije lo que sucedió y ellos dijeron, ¿cómo te contactaron?
Whenever she called the Garland Police Department, they arrived, it was a female officer and a male officer. Whenever they arrived, they asked her how did everything happen.
Entonces yo les dije, pues por aquí lo puse en esta página y aquí fue donde me contactaron. Entonces ahí logramos agarrar el número de teléfono de esta persona. Ellos le llamaron y la persona le respondió de que nomás lo había llevado a un taller.
When the officer asked her what happened, she stated that she had posted the vehicle in this site. This is where they reached out to her about inquiring the vehicle. The officers were able to retrieve the gentleman's phone number, so the officers contacted the gentleman through that information.
Sí, dijo que lo tenía en un taller porque él estaba checándolo el motor porque lo iba a comprar.
Whenever the gentleman answered to the officer's phone call, the gentleman stated that he had the vehicle at a mechanic shop, testing out the vehicle, making sure all the mechanical was done correctly and there was no issues.
Pues llegó la gente y me dijo de que no me preocupara, que nomás lo estaba checando.
Can I ask the translator to speak up just a little bit? I'm so sorry.
The officer stated that for Elsa not to worry, that the gentleman will be bringing the car back, and he was just having the vehicle checked by a mechanic.
Ellos estuvieron ahí por cerca de 4 horas. Le volvieron a marcar a la persona. Nunca regresó, nunca se volvió a reportar. Después que pasaron de 4 a 5 horas.
After 4 hours, the vehicle was still not returned to her. The officer tried to reach out to the gentleman again. There was no answer, no call back, no response back from the gentleman that was supposed to be bringing the vehicle back from the mechanic.
Entonces me dijeron que me iban a levantar un reporte, me dejaron un número de reporte y de que pues ellos creían que el vehículo ya no me lo iban a traer.
The officer stated to her that they were gonna proceed in filing a report. They gave her a report number and needed to get her testimony on how everything occurred. And the officer stated to her that the vehicle was no longer going to be returned to her by the gentleman.
Was the gentleman who took your vehicle the defendant Wayne Chandler, also known as Exo Chandler?
La persona que se llevó tu vehículo es Wayne Chandel, also known, AKA Exo Chandel. Yes.
When did you next hear about your car?
¿Cuándo fue la siguiente vez que usted escuchó de su vehículo?
Pues me cayó una carta de Houston, de un reca,
She received a letter from Houston from a impound company from Houston,
donde decía que tenía mi carro, que lo podía ir a levantar y que me iban a cobrar un dinero porque tenía como un día de estar ahí.
later the letter stated that she was able to go ahead and pick up her vehicle that was impounded, that she needed to pay a certain amount of storage fee because it's been there for a day or so.
Cuando recibí la carta, el siguiente día yo me fui temprano a recuperar mi carro.
When she received that letter the next day, she proceeded driving to Houston to retrieve her vehicle.
What happened when you arrived at the record service in Houston?
¿Qué sucedió cuando llegaste a la locación de la reca?
Llegué al lugar y enseñé el título, todo, mis cosas, y les dije que iba a recoger el vehículo, que estaba esta carta que ellos me habían mandado.
She stated that when she arrived to the impound, we showed the title and the information, the letter that they had sent her to pick up her vehicle.
Y luego cuando ellos buscaron su información, me dijeron que el vehículo ya se lo había llevado otra persona.
When they went ahead and started looking for the information on the system, once they looked it up, they realized that the vehicle has already been released.
Entonces yo les dije que cómo era posible que lo haya llevado otra persona si ellos me habían avisado y sabían que era mi carro.
She was asking, saying, how is that possible if I'm the owner, you sent this letter to me? How can you have released the vehicle to someone else if I'm the owner?
Entonces dijeron que la persona que había llegado, había presentado un biocel y que con ese se lo habían dado.
The lady there had advised, told her that the reason they released the vehicle was because another gentleman had presented a bill of sale, and that's how they were able to release the vehicle to him.
En ese momento, pues, le pregunté yo qué hacía y dijo, pues, que tenía que ir a poner un reporte en Houston de que el carro había sido robado. Y pues sí, fui a la policía
They stated to her that she asked, well, what else can I do? That's my vehicle. They advised her to open a police report of a stolen vehicle in Houston.
y en la policía me dijeron que no lo podía hacer ahí, que tenía que ser en una dirección. En una dirección de donde tenían que ir. Entonces le dije que si tenía unas personas conocidas que iba para ahí y iba a hablar a la policía.
She stated that they told him when she arrived to the police station that in order for her to do the police report, she needed the address of a location where to do the police report. So she stated that she had the information to where the vehicle were to make the police report, and she did that.
Was the person who presented the fraudulent bill of sale at the record service the defendant Luis Gerardo Ehrenbeid?
La persona que mostró el bill of sale fraude era la persona Luis Gerardo Ehrenbeid.
Sí.
Yes.
Okay. Was the fair market value of your 2014 Nissan Altima at the time it was taken from you $9,000?
Al momento que se robaron tu vehículo, el valor de la marqueta justa del 2014 Nissan Altima, el valor de $9,000.
Sí.
Yes.
Those are all the questions that we had for the witness, Your Honor.
All right, call your next witness.
That's it. That's what we've got. We've submitted a proposed judgment to the court for the fair market value of the vehicle to be assessed against both defendants jointly and severally. And in the exhibits, we've shown that with regard to defendant Wayne Chandler, also known as Exo Chandler, that he has, in fact, a previous criminal history. And this is one more crime he's committed by taking her vehicle. And we're asking the court to additionally assess some form of or amount of punitive damages against the defendant, Wayne Chandler, also known as Exo Chandler. We're not asking for those against Luis Gerardo Ehrenbeid.
Let me pull this up real quick. I did have a question for you because I think it's really interesting how you have this done. Is this a Zoom setting you're using to show the split screen? I thought that was really well done.
It's a piece of technology put out by Owl Labs that I actually ran into in a client's conference room about 3 months ago, and we used it for a proceeding there, and it worked so well that I came back and spent the money to get one, and it's been pretty useful ever since then.
Well,
So,
I am really impressed with that. I think it really adds to the Zoom presentation. So, money well spent. You have something here for exemplary damages. Do you
yeah,
see, so what were you requesting?
I would request just 2 times the actuals.
So 18,000, is that right?
18,000. That's correct, Your Honor.
Okay. I'm really sorry, ma'am, that you went through this. I think is that 18 or 8? I think that may be 180. We'll make sure I fix that.
Yeah.
Dice que se disculpa que perdón por lo que está pasando, que siente por lo que estás pasando. Gracias. Thank you.
All right. Any other corrections to this that I need to make? Did you see, Mr. McCordle?
I don't think so. I think it looks fine.
Okay. I'm going to go ahead and send this to the court clerk right now, and it should hopefully be on the system by tomorrow.
Great. Thank you, Your Honor.
You guys have a great rest of your day, and good luck with everything.
You too. May we be excused?
You may.
Thank you.
And that was Owl Share, you said, or what was it called?
Oh, Owl, OWL Labs.
And what's the name of the software?
It comes with its own application. It's just called Owl.
Okay.
I would pick it up and show it to you, but it's got a series of cameras in the top that focus on the individual speakers, which is why it sometimes slides back and forth between 2 and 3 people.
That is very, very cool. Very cool. I want to
Yeah.
take a look at that. I'm kind of interested in that kind of technology. So anyway, great job. And again, you have a great rest of your day. Okay.
You too. Thank you. Take
All
care.
right. There's a Miss Sorter here, Michelle, Sortor. Ma'am, what are you here for?
Yes, Your Honor. I am here, I think I'm a little early for the 4:15 hearing on Minnie Gray versus the Sophia Apartments.
Okay, great. Okay, you were a little bit early, but we will take care of you guys when everyone gets here.
Thank you, Your Honor.
Good afternoon, Your Honor.
Good afternoon. Couple issues I want to chat with you guys about. First, I think is the motion to withdraw. Is that correct?
Yes. Plaintiff motion to withdraw in the matter BC-21-17515.
All right. Did you get that, Tony?
I'm sorry, no.
Let's go on the record on DC 21-17515 Gray versus the Sophia Apartments. Counsel, make your appearances.
My name is Mehdi Wagefi on behalf of the plaintiff Minnie Gray.
Michelle Sorter for S2C Partners LLC and S2 Hub LLC.
First off, is there any objection to this withdrawal by the defendant?
No, Your Honor.
And as I understand it, the plaintiff is not here, correct? You put her on notice of this hearing.
The plaintiff has passed away and the defendants filed.
That's right. This is the one where the defendant's heirs don't want to participate, correct?
Yes, the plaintiff heirs. Yes.
And the plaintiff's heirs have been put on notice of this hearing.
Yes, so by the court ruling, plaintiff had the time to amend the petition with the affidavit, with an affidavit that is physically and mentally capable for proceeding the matter under his name, but the plaintiff's heir didn't cooperate with us and didn't sign the affidavit within the time actually by the court order.
Okay. I'll allow the motion to withdraw then.
Thank you, Your Honor.
Okay. And then this case is currently, I believe, set for trial. This is set for trial on June 6th. Anything else we need to do to get today, Ms. Sorter?
Well, Your Honor, we would just like some guidance as to how we're moving forward. We don't have a plaintiff or a plaintiff's representative, and there's nobody to prosecute this case as we're moving forward. Minnie Gray has deceased, and there's nobody on her behalf or on the behalf of her estate who's come forward to represent her interests in any manner. And so what we have is we're 6 months out from a trial where it looks like there's going to be an empty chair at the plaintiff's desk. And we have filed our motion to dismiss, which we can set for hearing. We can do whatever it is that we need to do on our end. We're just looking for some guidance to the court as to, first, what we're supposed to do about this trial setting, and then second, how the court would prefer that we proceed given this situation that has come up where there is simply no plaintiff and nobody to prosecute the matter.
All right. I don't have any problems you setting this for hearing. It's currently set on June 6th, so we may want to move that. But it's up to you.
Well, we certainly do, would want to move the trial if the trial is going to take place. We don't have a plaintiff. We don't have anybody prosecuting the case. And we filed our motion to dismiss, which we can set for hearing if that's what needs to happen.
Okay, so according to I want to make sure I'm up on the Texas Rules of Civil Procedure, you probably already know this, 99B. If the personal representative or heirs do not appear and prosecute the suit by 10 a.m. on the first Monday after the expiration of 20 days from the date the seri facias is served, the defendant can ask the court to dismiss the suit for want of prosecution. So have the heirs, when does that, the heirs have been served with the writ of seri facias, is that correct?
They have not, Your Honor, been served with, they've not been served with anything. It's our understanding that well, the heir was going to be represented in the case, and it has now, I'm not even sure if Miss Gray's counsel was able to reach Mr. Gray at any particular address or any information like that, if we have any way of contacting him.
Do you have contact information for him, sir?
Yes, Your Honor, I personally spoke with him and about the affidavit. So the only issue that we have with Mr. Gray, we know his address, place of residence, we communicate with him. I already spoke with him, but he doesn't cooperate with us about signing that affidavit. That's the only issue.
So I think what has to happen procedurally, if you want to look at your, I don't know if you have the O'Connor's Texas Rules 2022 on it. On page 132, it says, if within a reasonable time, the plaintiff representative or heirs do not find a suggestion of death, which I think has occurred here, and appear to prosecute the suit, the defendant should file a suggestion of death and ask the court to issue and serve a writ of stare facias similar to a citation on the representative or heirs. If the personal representative or heirs do not appear and prosecute the suit by 10 a.m. on the first Monday after the expiration of 20 days from the date the stare facias is served, the defendant can ask the court to dismiss the case for want of prosecution. So it seems like the proper procedure, and I'm not fussing with you, Ms. Sorter. I hope you don't feel that way.
No, not at all, Your Honor. We appreciate the guidance.
Yeah, and it is that I think what needs to happen next, I mean, and again, this is just a suggestion at this point, is that we continue the trial setting for a couple months, 3 months or whatever. I'm flexible. And then during that time period, you probably want to go ahead and send them a stare facias. If they don't appear within the requisite time, then you ask for a dismissal for want of prosecution. But I'm open to suggestions if there's something else you think would be better.
Your Honor, we can certainly attempt to serve Mr. Gray, and we will file that with the court, and we will do everything that we need to do. And then if he does not respond, then we will re-urge our motion to dismiss.
All right, Mr. Vigaletti, you need to provide her a copy of the most recent address of all the heirs or personal representatives you're aware of by the end of the day tomorrow.
Your Honor, I'm sorry. I listed in our motion to withdraw the last number, the phone number, and the address and the apartment number.
For all heirs that you're aware of?
Just Mr. Jesse Gray, and also I aware of Miss Gray's daughter. I will provide that address and information. She never responded to our calls and letters, but I will provide the information to her by end of today.
And Ms. Sorter, I think in abundance of caution, you probably should serve both of them just in case, so that, you know, we go through this process appropriately.
Yes, Your Honor.
Okay, so when do you want me to reset this for trial?
Maybe like mid-September. That should give us hopefully enough time to get everybody either served or confirmation that we're not going to be able to get anybody served at the addresses that were provided, and then we can file whatever we need to file and move forward with getting something set before the court if we need to.
Okay, we'll set this, Ron, to reset this to September 5. That should give you enough time, don't you think, Ms. Sorter?
Yes, Your Honor.
To reset this case to September 5 and then go through the appropriate process. And if they make an appearance, then we'll talk about moving the trial setting again if we need to. And if they don't, then you can file your dismissal on prosecution.
Thank you, Your Honor. We appreciate it.
All right. You guys have a great rest of your day and you be safe, okay?
All right. Thank you, Your Honor.
Thank
Are we
you.
excused?
You are.
Thank you.